Okay, we'll go ahead and go back down to Las Vegas. Who'd ever like to start? Go ahead and state your name for the record when you're ready.
Madam Chair, Christina Pickering. I support AB 267 as written and passed by the Assembly. DeMarlo Berry's case came to me on his appeal from the denial of an evidentiary hearing on his third petition for a writ of habeas corpus. The case was filed in the Nevada Supreme Court. We heard oral argument and we decided it on December 24th, 2015. We reversed and remanded for an evidentiary hearing on a gateway claim and discovery. He was not allowed discovery because his third petition for a writ of habeas corpus was summarily denied as procedurally barred. There followed the DA's post-conviction review process, but up until that point, he had been resisted at every turn, and the litigation system raised all of the roadblocks to setting aside the conviction and granting a new trial that we've been discussing here today as meriting a higher burden of proof and more rigorous, more expansive standards. The bill is elegant in its simplicity, and it is designed to work in an expedited fashion to allow a person whose conviction has already, through court process or DA process, been set aside and a determination made that this person will not be retried. It is at that point that this bill even starts to apply, and the question then is actual innocence and compensation. I urge you to keep this process simple and straightforward as the bill has been drafted. An accessory cannot recover. A person who the DA is wanting to retry cannot recover. So the DA retains control over the process. It took Mr. Berry 22 years from the date of his conviction to getting a reversal for an evidentiary hearing on Christmas Eve in 2015. I'm here as a person, not on behalf of the court system, and the only other bills I've ever testified in favor of were the adoption of the Court of Appeals. But I feel deeply and sincerely and passionately that ours, while it is the best and most elegant dispute resolution system in the world and one of the finest, when it makes a mistake, we need to step up and we need to do what we can as human beings to expedite reparations for those wrongs. I cannot imagine to have my freedom, my liberty, taken from me for 23 years, as Mr. Berry's was. He's entitled to, he and others in his position are entitled to reparations from the state and more than a drop-off in North Las Vegas. I have never met Mr. Berry face to face, but I want to extend my apologies to him and my congratulations to the extraordinary grace and dignity with which he fought this wrongful conviction. He said the same thing from start to finish. I read the entire transcript on all of the proceedings, and I urge you to adopt AB 267 as formulated. Thank you for listening to me.
Thank you for being here. Next testifier in Las Vegas. Go ahead when you're ready. Thank you.
Thank you, Madam Chair, members of the Senate Judiciary Committee. My name is Douglas Herndon. As some of you know, I am also a judge. I'm a district court judge here in Clark County, Nevada. Like Justice Pickering, I don't speak really on behalf of the judiciary or even on behalf of the 8th Judicial District Court. I am more here just as an individual to offer my support for the bill as written and proposed. I have what I would consider to be a somewhat unique perspective or placement in this whole process, not just because my daughter was blessed with the opportunity to extern with Justice Pickering and then become involved in the research that helped lead to the bill that's before you, but because I was also a prosecutor who was involved in prosecuting a case in which a gentleman was convicted of murder who was later found to be factually innocent. And if you think that doesn't weigh heavily on somebody, you would be mistaken. I think that informs me every day that I do my job currently about the failings that can occur within our justice system. We learn through our religious teachings as well as just the living of our lives that, you know, we can't solve all the world's problems, but we are not free to abandon them either. We have to walk with humility and responsibility and recognize when issues occur, and that there's never, ever a wrong time to do the right thing by people. And you don't have this legislation in front of you unless somebody's conviction has been vacated in some fashion. We're not talking about convicted individuals trying to use this statute to somehow reverse their conviction. Their convictions have gone away for whatever the reasons they've gone away. And at that point in time, under our Constitution, you are presumed innocent again, and it should be a simple process for people to come back before the court at that point and seek some type of remedy under this statute to help them move forward with their lives. We shouldn't make it more difficult in any fashion. I know when my daughter first was involved with Justice Pickering and this was being put together, and she had an opportunity to meet with Assemblyman Yeager, Mr. Silverstein from the DA's office's Conviction Integrity Unit, as well as Mr. Wolfson, there was a lot of full support and buy-in for what was being put forth. And I trust all of you, as well as the Assembly members who have very wisely crafted the language that's in place right now. And I don't think that there really needs to be any effort to change that in any fashion. It protects whom we need to protect. It protects the people of our state. It protects our court system. And it protects individuals like Mr. Berry, who I have had the opportunity to meet, he and Adelia, face to face. And I can't tell you how impressed I was with the grace and integrity of those individuals in light of what they went through, and the very warm way that they adopted my daughter, to be quite honest, and spoke to her about what should inform her as to the rest of her life. And you can only hope that people would be able to express that level of humility despite what the state has done to them. And any opportunity that we have to make that right should not be a complicated process. It's one of those things where we're all best served if we keep it simple and do what we can to make it easier for these folks to get back before the court and seek some type of remedies under the statute. So I appreciate your time today, and I trust your wisdom moving forward that this will be passed as written. Thank you.
Thank you. Is there any